Thank you so much for the introduction. My name is Steve Roseman, Managing Partner of Roseman Law, and today I'll be bringing you a seminar on the subject dealing with bullying and harassment within your communities. This issue is becoming more and more of a significant problem in many of our communities, and we're going to go through the type of bullying from various aspects of it, who is exposed to and experiencing bullying, and then mechanisms, both legal and alternatives, in addressing this issue within your communities. So first of all, what is defined as bullying? Bullying is an attempt to harm, intimidate, coerce, oppress, torment, force, or compel, strong arm, or pressure someone perceived as vulnerable. It's a very broad topic, and we all know what bullying is in a school environment, but this environment is as effective. And we're going to run through some of the alternatives and dynamics that exist with regard to that. So first of all, where does bullying occur within common interest developments? We often see it occurs from one board member to potentially a property manager or a fellow board member. Sometimes you see it with a homeowner who's bullying or picking on or harassing a board member or the property manager. Sometimes it's a board member to that homeowner, or a board member and a homeowner to a third-party vendor, or just between two homeowners that this issue occurs. So briefly, I'm going to describe the 4 types of bullying that exist. So first of all, it's that verbal bullying, that harassment, that bullying where someone says mean, cruel words, yelling, screaming, disrespectful comments, etc. That's the type of bullying we know, whether it's done in a phone call, whether it's done in in-person meeting. So that bullying is what we call verbal bullying. The next type of bullying is relational bullying. In that situation, it's a tactic whereby people are excluded. So the exclusionary tactics where you're deliberately preventing someone from being part of a group. An example of that is where there's discussions of board business without including them, leaving them out of certain email chains, and excluding them from being part of the board when it comes to decision making of the board. The next type is the actual physical bullying, that physical intimidation, whether it's just shoving or pushing or kicking or tripping. Those are examples of that, or even slamming your fist on a table, being pushed in the hallway. That's a physical type of bullying that occurs. The last type, which is more common, that we see very often, is what's known as cyberbullying, where those harassing emails are sent. Rumors or lies are spread via email or text or some other form of social media. And that cyberbullying is another form of bullying that is actionable and can be prevented. So the important question is, how do we deal with bullying? I'm going to deal with various scenarios. Let's deal with the first situation, as I mentioned at the beginning of this presentation, where it occurs from one board member to another board member, or from one board member potentially to a manager, who the common interest development manager who's overseeing or attending the board meeting. So what actionable items or availability does a board have in dealing with a board member who's bullying or harassing? The first method is a censure. And what a censure effectively is either in the form of a letter or in the form of a hearing where you call that board member to a meeting or sending a letter advising them that their action is a breach of their fiduciary duty. And there are various forms of breach of fiduciary duty, whether it's a breach of confidentiality, whether it's a violation of other governing documents. And that censure letter would be effectively putting them on notice about their violation and why they need to cease and desist in what they're doing in their actions towards other board members or management. And that's known as a censure. Now, as far as censure is concerned, it's a formal reprimand of that director. Now, as I've said, giving you some examples, if there's a disruption of meetings, shouting or profanity, if it's a breach of confidences and confidentiality, interference with association operations, and other forms of breach of fiduciary duties, that is why you would then proceed with a censure. In matters where a censure may be a proper forum, what you may do is do a noticed hearing and call that individual director to that hearing. Minutes will be recorded to document that meeting. It can be done either in executive session or it can actually be done in an open forum. If they're going to be privileged communication discussed, it's probably better to do it in an executive session. Otherwise, you can do that in a forum where it's open to the rest of the owners in the community. Once that is done and it's documented in the minutes, you will be aware that this person has been censured and what those actions are, and those owners, if it's in a regular meeting, will have access to those minutes. You cannot remove a board member as a board member without a vote of the members. So you may remove them as an officer, but not as a director. So now we know that censure may or may not work because they're still actively involved on the board. What's the next available options? Well, if there is some form of threat or there's a possibility of great or irreparable injury that will result from an action of that board member to another board member or management, you can proceed with a civil harassment restraining order or a temporary restraining order. Now, you would have to show evidence of imminent threat or potential threat of, and harm. So although this is a good tool to stop behavior and even get a restraining order to stop them from coming within a distance or emailing or making phone calls, you have to show an imminent threat. Why that's important is because the standard in evidence is much higher than in a normal situation where you'd get a restraining order or preliminary injunction, which we'll speak about in a few minutes. So in this scenario, you want to make sure that you document immediately if this behavior rises to this level. Second, if necessary, and I strongly advise, report it to local law enforcement, make a police statement about the threats so that there is the evidence to support this type of restraining order. We will talk in a few minutes about injunction, but at this stage, those are two avenues. And in addition to that, some of these tools can be used as well against another board member. But I'm now going to go on to situations where an owner is harassing a board member or a manager or some third-party vendor, or even another board member is taking action against or harassing any of the following as mentioned above. So let's talk about a few of the options. So let's assume there is a homeowner in the community that disrupts board meetings. This homeowner yells and screams at the property manager. This individual goes out to the vendors who are working in the landscaping and instructs them to do different things that then they've already been given instructions on by the board members. And you need to stop this type of behavior in order for our vendors to be able to do their work, or the manager to do their work, or even the board members to be able to effectively operate. The first thing is calling them to a notice and hearing. That's posting a notice and calling them to this hearing. Make sure your rules have some form of code of conduct that you can call them to a hearing based on those rules. You will then explain to them what their violations are and advise them that if they don't cease, you can either impose a fine or some other restrictions as set forth in your governing documents. You may also advise them that they need to cease and desist this activity, otherwise it will escalate to the next level in dealing with this issue. So the first one, notice and hearing, and you can bring them to notice and hearing. Sometimes prior to doing that, you may just want to have a cease and desist letter, which will stop their activity, but often doesn't work. An IDR, internal dispute resolution. The Civil Code allows for a homeowners association board, or an owner for that matter, under Civil Code 5905, to call that individual to a hearing with one of or two board members in attendance, or manager for that matter, to discuss this issue in an attempt to amicably resolve this issue. Doing it in an IDR format has some value in the sense that they will informally discuss this issue and try and resolve it. Bear in mind that anything discussed at an IDR, internal dispute resolution, has no privilege as with a mediation, which we'll talk in a minute about. So therefore, anything that's said in that meeting can and will be used against the board member. So be cautious in what is discussed, keep it very factual, always have two people in attendance with that individual to be able to address these issues. If you do request IDR, that individual owner doesn't have to accept. If an owner requests IDR from the board is obligated to comply with that request. Temporary restraining order. We've spoken about the temporary restraining order. The one civil harassment restraining order is done through the courts, which allow law enforcement to be able to act on that. That's the imminent threat. The other type of TRO is a situation where it's done pursuant to the CC&Rs, and your governing documents have a provision relating to harassment or nuisance, as the general term is. And you can get that restraining order, TRO, temporary restraining order, on short notice, 24 hours, but you have to show why this cannot be done on a normal notice motion, which we'll talk in a minute about. So assuming you're not proceeding with the TRO, the IDR hasn't worked out, notice and hearing, imposing a fine, another suspension hasn't worked, what actions do we have available under the governing documents? The next action is known as an injunction. If an individual is creating a nuisance, as defined by the governing documents, it's a very broad definition, you are able to bring an action and file a lawsuit and ask the court to issue an order holding that person or instructing that person not to perform whatever acts they are doing. So if they're harassing, disrupting board meetings, if they are sending harassing emails, if they're constantly calling and creating a nuisance that way, you can get an order from the court ordering them to cease that type of action. Prior to filing an injunction and a lawsuit, you have to go to alternative dispute resolution. So you put that owner on notice, sending that owner a letter advising them that we're intending to bring an injunction to stop your action, but we're giving you an opportunity to mediate this dispute. You have 30 days to accept this mediation. The fee will be shared equally, and we normally go before a judge or some other mediator to try and resolve this. If we go into that mediation and resolve it, great. Anything discussed in that mediation is privileged communication. If it doesn't resolve in that mediation forum, or that particular owner doesn't accept the mediation within 30 days, then you're able to proceed with a lawsuit. Why do you have to go to the ADR before the lawsuit? It's mandated in the civil code, and in order to ensure that the association recovers your attorney's fees, you want to make sure you follow the ADR procedure prior as a precursor to filing the injunction. So it doesn't resolve itself in ADR. Now we proceed with an injunction. We get the court, we file a lawsuit, we file the complaint. Simultaneously with that, we file what's known as a motion for preliminary injunction. Attached to that document are declarations setting out exactly what the action is or the actions of that individual owner for purposes of supporting the injunction or the order of the court instructing that person to cease whatever activity that person is doing. So you then file the motion, file the lawsuit, serve it on the person, and at minimum of 21 days, you schedule a hearing for that. That person would have to appear in court, either on their own or with an attorney, file an opposition to this injunction. If the court grants our injunction and instructs that owner or person to cease whatever it is that they're doing, we now have a court order in place that instructs that person to cease. You will then still continue to trial in a year's time to make that preliminary injunction a permanent injunction. But with a preliminary injunction, it's an extremely enforceable document. What happens if the owner or individual doesn't follow the injunction granted by the court? The next avenue available to the association would be to bring an action for contempt. And a contempt action is where you say to the court, Your Honor, you granted this injunction instructing this individual to cease whatever the activity was that was set forth in the injunction. That person is violating your court order. Therefore, you can hold them in contempt, and with that comes potentially up to 5 days in prison and a monetary fine or a monetary fine to be able to ensure that that person complies with that. And I can tell you from experience, we've had situations where we've had injunctions granted, they violated the court order, and as a result of that, the court has issued a bench warrant on a contempt hearing to have them picked up by local law enforcement for violating a court order of the court. So now that we've gone through the various tools that are available to a board to be able to address harassment and bullying by whether it's another board member or by some owner in the community, I hope this gives you some tools. We're always available to discuss these issues, but it's important to make sure you take action, whether it's just simple action or some type of legal action to address these issues, to allow a community to exist and function in a harmonious and an environment that allows for the community to coexist well together. Thank you very much.